when we came, we realized that some of the documents were not readable. Documents they filed. And so we told the court that we cannot read these documents. They are not readable. And the court also looked through the file and also realized that it is true that those documents couldn't be read by anybody, notwithstanding even application of a magnifying glass.
Counsel, when you said they were not readable, what do you mean by that?
They were too faint to understand what is there. You can't read it. So we told the court that if the court would find that the court's copy could be read, then we could share. But the court also realized that they couldn't also read their own copy. And therefore, a need for them to bring good copies, readable ones, for us all to apply ourselves to those copies. So, matter was adjourned to tomorrow for the prosecutor to bring us readable copies of those documents we complain about. So we'll come back tomorrow to take the CMC if they are able to serve us with the readable copies. On the other hand, if they decide not to serve us with readable copies, then those documents ought to be expunged from the records. Then we can proceed thereon. So for today, we are waiting for readable copies of the documents they have filed. We hope that by the close of the day, they will be able to serve us with readable copies for us to come back and do the case management.
What are these documents and how critical are they to this case?
They are documents before the court. We haven't even taken them. We haven't admitted them. We haven't applied them. So we are foreclosed in disclosing what is in there. But I can only say that there are documents that are not readable, for which we raise objections. And the court ruled that we should bring readable copies.
Do you think that this was an intentional step taken by the prosecution to frustrate the case?
No, I cannot undermine the work of the prosecutor. And I don't understand why it happened the way it did. And I also know that if there are readable copies there, they can furnish all of us, including the court, of readable copies for us to proceed. So as for today, what I can say is that these copies were not readable. And without more, we will wait for them.
I think, and after this case, you went to commercial court.
Yes.
What happened?
We have moved our motion. It had been responded to by EOCO, and the matter has been adjourned to Thursday for a ruling, if it's ready. If it's not, we'll take another day for them to come and do the ruling.
But what was the argument?
We are saying that they did not comply with their own governing law of the requirement of service of court processes on the person affected by the freezing order of EOCO. And the argument was that they have served copies of documents on me as counsel, and that they considered that service. My argument was that they have served me a lot of copies in different situations, but the law requires that the person affected by the prison order ought to be served, and timeously too. There is also a time limit within which service ought to be done, 7 days. And we are saying that they haven't served us even as we have now. And we relied on Order 7, Rule 1, 2 of the requirement of service on a person affected, not on any other person. So this was the argument. So we wait for the court to rule. That we are saying that even as at now, we have not been so served. And we are saying that we are not statute barred. Because that was one argument of the EOCO, that we are out of time in filing the application. We are saying that time begins to run when notice is given to us. And that notice was also given to us when we've signed a check for the bank to pay. Otherwise, EOCO itself had not served us anything. And therefore, time will run from the day that we got notice of the freeze, not the day that they probably Nicodemously gave the order of freezing the accounts. So time will start from the day we got notice. That is our argument. So let's wait for the court to rule whether time starts, even if you do something in darkness. And I want to believe that, yes, we have stated the position of the law and cited case law to support our argument, and also stated position in the High Court Civil Procedure Rules, which talks about also service. So let's wait for the court to reconcile the two arguments and come out with a ruling.
So your client has been coming to court almost every week or two. How is he feeling looking at all of these legal tasks?
Well, the laws of Ghana requires that you appear before court if you are summoned. And if you look at the front page of every writ, it is so stated that if you don't come, the matter can continue without your presence. So it is a requirement of the law that when you are summoned to appear before a court, you ought to show presence. So my client has been religiously responding to all such invitations. And you bear me out that my client is almost the first person to come to court on each court date, and that we will not also attempt to delay the proceedings. We are always ready. So when the court is ready, we are always ready. Thank you.
Hey, what's up? Wontumi. Which means me are